Hi, everyone. Welcome to our video for Unit 3. As I mentioned in the introduction to this unit, you'll see on the welcome page when you get onto Blackboard, which obviously you saw if you found this video, that we're going to be spending this week and next week talking about communications in the law firm. Obviously, the idea of communicating is a critical piece of anything we do in any type of law office. So there's a lot of different pieces to cover. I think Chapter 3 does a really good job of outlining the types of communications that we have in the law office, introducing you to some of the ethical obligations. And then one area that I really wanted to spend time highlighting on the PowerPoint was some general advice about using phones and using email. I am sure you've talked about this in other classes, other work environments, but I think it's really critical for us to pause and talk about it in the law office. And I'll talk about why that is when we get into the PowerPoint. So just a little review of some of the items covered in the chapter that I also ask you about on the discussion board that I think are worth mentioning here is first talking about how it is that we communicate. There are so many different methods as to how we communicate in our personal lives and in our professional lives. And that is the same and true in the law office. I mean, take a minute to just think about how it is that you communicate with people. We obviously meet with people face to face and in meetings, although less so during COVID times. But I mean, in a non-COVID setting, we meet face to face. Obviously, in COVID times, we're replacing a lot of what would be face-to-face meetings with Zoom. So the idea of having live interaction with people doesn't go away. We communicate with people over the phone, although I give you a picture here of what might look ancient to you, but this is an office phone, and we're going to talk about that. Maybe you guys picture phone and you picture this flat thing like this that looks like a phone. Quite a few years ago, we might have looked at that and said, that's not a phone. I don't know what that is. We also communicate using the phone via text message that I did not even put a little picture of here. And certainly we communicate over email. So I want to go through a few of these in this particular PowerPoint. So again, the ways in which we communicate in the law office mirror the way we communicate in real life. The law office uses telephones. In addition to telephones, the law office uses mail. And I'm going to use the word mail to describe the mail that comes in an envelope delivered by the United States Postal Service, in addition to packages that might come from private companies like UPS or FedEx or DHL. But when we talk about mail, we're thinking what the Postal Service delivers and what you send out by mail, separate from the electronic mail of email. Believe it or not, some law offices still use a facsimile or a fax, although I think fax machines have reached their peak and now, they're really kind of on their way out. And then we'll also talk a little bit about text messaging in this unit and next unit as to whether we should use text messaging as a way to communicate with your coworkers, with your clients, with other individuals that you might be communicating with. So obviously, multiple ways that we communicate. So let's just take a minute before we sort of get into some of the nuts and bolts of these communications to step back and say, why do we really need to talk about this in a class called Law Office Management? And that's really because we need, and that means you and me and the lawyers, we need a comfort level with all the different methods of communication. We might have our preferred methods of communication. I've asked you that on the discussion board. Maybe some of you love text messaging. Maybe some of you love to talk on the phone. If I hearken back to my teenage days, I think I spent hours and hours talking on the phone with my friends when I was 13, 14, 15. And the truth is, even to this day, I'm still pretty comfortable talking on the phone. I still like to do it. Not everybody does. What about typing or writing as your method of communication? Are you comfortable communicating a message to another person in an email? For example, if you have to email me and ask me for an extension on a homework assignment or to talk about advising, are you comfortable writing that or do you get nervous? At the end of the day, regardless of where you are today, I hope that by the end of the semester, you gain some confidence in all methods of communication, because the truth is we have to be fluent in all of them because that's just how we are as a law office. Sometimes we have to make and receive phone calls. Sometimes we have to receive and write written communication and so forth. We clearly can't be relegated to one type of communication. The other reason I think it's really important to stress communications in this class is to tie it in with one of the themes that we're talking about all semester, which is ethics. Again, it's really impossible to have a conversation about having phone conversations with clients or opposing counsel and not talk about the rules of confidentiality, or think about emailing your client a document for them to review and not talk about the risks of what if a third party intercepts that document or that email? What happens if you send it to the wrong, you have Smith in your electronic Outlook, storage of contacts and you email the document to the wrong person? We have concerns that tie to our ethical obligations to our clients. And when we talk about how to communicate, we're always doing it under this umbrella of ethics. I mean, really everything we do in the law office is under this ethics umbrella, and communications falls there too. So as I said, we're going to talk about different ethical rules throughout the semester. So here's a good place for me to introduce to you really one here in the PowerPoint, one of the ethical rules, and you'll have an opportunity in your homework assignment this week to do a little bit of a deeper dive into the rules of ethics and take a look at them. Okay, but I do want to mention them here, and I usually don't put so many words on a slide, but I think it's worthwhile. And that's because I want to talk about the difference between the rule of confidentiality, that is, keeping your client's matters confidential, and the rule of the attorney-client privilege. Because both of these are terms that are tossed around a lot. If you watch legal movies, TV shows, you hear about attorney-client confidences and you hear about the privilege. But let's really define them here. And again, through your homework, you'll have another opportunity to look deeper at this rule. So we've already talked this semester about the rules of professional responsibility, which are the rules that all attorneys must adhere to be ethical in their practice. And as paralegals, you are in that fold. So you're part of these ethical rules as well. Not only should you look at them, but the attorneys who delegate work to you are still ultimately responsible for you adhering to these ethical rules. So it's not like the attorney is going to say, oh, I'll just give this to the paralegal and then I don't have to worry about ethics. No, you're in the fold. You're in the family too. Okay, so one of the key ethics rules is this one. It's Rule 1.6. And again, I've linked for you all the Massachusetts Rules of Professional Responsibility. You can also look at the ABA's Rules of Professional Responsibility that are the model rules, and that the jurisdictions around the country model their rules after. So Rule 1.6 squarely addresses the attorney's obligation to keep confidential information relating to the client. So if you have a chance, pause. I'll let you read the rule for yourself. I won't take up the time here, but take a minute, pause the video, and read the rule. You can see that it's written in the form of a command. It's not a should. This is a command to attorneys to not reveal the confidential information unless there are some notable exceptions that, of course, you can see when you look at the rule itself. And there's a certain amount of information that has to be shared just so the attorney can conduct representation of the client. But in general, the way to think about this rule is to really think about anything that is discussed in your law office, even the identity of your client themselves, or the matter in which they're working on. Maybe you represent a company that's been sued. It may even be that the matter that you represent the client on is even in the news. So for example, let's say it's a allegation of a crime, and you represent a criminal defendant in the allegation of a crime. And it could be that the crime itself has been reported on the nightly news, and you're representing Bob in his defense. You really should not be going around talking about the fact that you represent Bob, and certainly nothing else that you know about the case. Because even though this is a matter of public knowledge that the alleged crime took place, what you have learned and what you've become aware of due to your representation should not be shared. So it's almost like you want to think about having a bubble over yourself and the work that you do. And you don't want to puncture that bubble. You don't want to go home at the end of the workday even and share with your spouse or other family members some of the difficult matters you've had at work because you might be disclosing confidential information. And I just want to pause for a minute and make sure we understand the word disclose, because to me, it's not an intuitive word. It means not to share something, right? If you disclose something, then you have shared it. So you have a duty to not disclose or share or tell about that confidential information. So that's a little bit about the rule. You can see that this is sub A. If you drop down to sub C of the rule, the other necessary part to the obligation not to share the confidential information or disclose it is that the lawyer, and this means you too, the paralegal, shall, again, obligation, make reasonable efforts to prevent the accidental disclosure of that information. So you can see what, and again, I actually ask you in your homework assignment to define this term, inadvertent disclosure of documents, but it really means just accidental. So let's take a minute and think about what that means. You've got a bubble around yourself and your workplace and all the work that you do for your clients. And you have an ethical obligation to keep those matters confidential. So that's part one. But then part two is that in addition to just having that obligation, there's a second obligation to make reasonable efforts to make sure that we're not accidentally sharing that information. And you can see exactly how this rule ties into the concepts of communications. Because what we don't want is a situation where you're on your phone, and this is really the only phone I have in my house. I don't have an office phone. So I take it and I'm talking on the phone and I'm walking through the grocery store while I'm talking about client matters. So who can hear me? Everybody. Or I'm working on an email and I accidentally send some confidential information to my friend who's in my contacts who has the same last name as a client. So the obligation to maintain confidentiality is, first of all, twofold, that you have the obligation to keep client confidences, and secondly, an obligation to prevent, to take reasonable efforts to prevent that disclosure. But you can see how those taking of those reasonable efforts, that is directly connected to the types of communications that we use in our personal lives and in the law office. So that's piece number one to kind of overlay here. But notice that I haven't talked about attorney-client privilege. Attorney-client privilege, although sometimes these terms get exchanged or confused, really means something very different. What we've been talking about with confidentiality is exactly that. It's the ethical obligation to keep confidences. The attorney-client privilege is actually much narrower. The confidentiality is a big one. The privilege is narrow. The word privilege we see in multiple contexts in the law, and we interpret it to mean that conversations between two different entities are held private, that can't be just found out by anybody. And it's really a rule of evidence. And what that means is that a court of law during a trial, when the judge is trying to determine which evidence is allowed to come in and be introduced against a witness, there are rules of evidence describing that. Privilege is a rule of evidence. So in short, it says an attorney cannot be called to testify as a witness and being asked to say under oath, well, what did your client tell you? What did you tell your client? What advice did you give? That is the essence of the attorney-client privilege. I see that I'm nearing the end of my 15 minutes. I'm going to stop this video and I'll pick up so then you all can watch part two, and we'll pick up right here, finishing talking about attorney-client privilege.